I was asked to chat about a little bit about the history of Catholic education in Alberta, and I've decided to narrow that topic a little bit to tell you about the entrenchment of the constitutional right that you deserve and that you enjoy in the province of Alberta, and how critical it is to hold on tightly to that constitutional right no matter what. So let me start off in Charlottetown, PEI, in 1864. It was, what, does that sound like a little bit farther back that I was going to take you? Okay, that's fine. The Fathers of Confederation meet in Charlottetown in 1864 to talk about putting together a new country. They were worried because, of course, the American Civil War was just ending, and the Americans had a lot of armies in New England particularly, and they were a little bit worried that we better put together a country north or else we wouldn't have that opportunity. But the biggest problem in putting together a country north of the United States was what was then called the denominational schools question. It's exactly what we're talking about today, and that is constitutional protections for minority school rights. And the two major speakers in Charlottetown in 1864 were Thomas D'Arcy McGee and Sir Alexander Galt. McGee speaking for the Catholic education rights, and Alexander Galt speaking for the Protestant education rights, mostly in the province of Quebec. What was going to become, post-discussions in Charlottetown in 1867, the province of Quebec. And one of the best summaries of what happened in Charlottetown in 1864 was in a speech by the Prime Minister, Sir Charles Tupper, in the House of Commons in 1896. And here's what the Prime Minister said about how important it was to have constitutionally protected Catholic education in Canada. He said, they always spoke formally in those days, "I do say, within the knowledge of these gentlemen, that but for the consent to the proposal of the Honourable Sir Alexander Galt, who represented the Protestants of the great province of Quebec, that in the Confederation Act should be embodied a clause which would for all time protect the rights of minorities, whether Catholic or Protestant in this country, there would not have been a confederation. It is important, it is significant that without our agreement, without this guarantee for the rights of religious minorities to be embodied in our new Constitution, I would have been unable to forge confederation for this country whatsoever." That is a pretty telling speech. Canada does not exist without Catholic education constitutionally entrenched. It would never have been created. We would all be part of the United States at this point in time, but for Catholic education. So, in the Constitution Act of 1867, we have Section 93, which is that protection. Section 93 reads, "Nothing in any law, shall prejudicially affect any right or any privilege with respect to denominational schools which any class of persons have by law in the province at the date of the Union." That section of the Constitution Act of 1867 is still there. It has been protected continuously in legal battle after legal battle, political campaign after political campaign since 1867. It was a critical point of discussion in 1980 when the provinces and Prime Minister Pierre Trudeau were negotiating what was going to go into the Charter of Rights and Freedoms in Canada. And there was a discussion about whether there should be a continued protection for Catholic education in Canada. And the result of that discussion in 1980 was the addition in the Charter of Rights and Freedoms of a reinforcement of the right to the constitutional existence and constitutional ability to teach Catholic education in this country. It's Section 29. It reads, "Nothing in this charter abrogates or derogates from any of those rights or privileges guaranteed by or under the Constitution of Canada in respect of denominational, separate, and dissentient schools." So in the Charter of Rights and Freedoms, there was a protection in 1980 for that clause negotiated way back in Charlottetown in 1864. And as you know, the Charter of Rights and Freedoms is largely what we deal with in terms of constitutional protections and constitutional rights at this point in time. So then we move into the creation of the Western provinces, Manitoba, Saskatchewan, and Alberta. It all starts in 1870 in Manitoba with the Manitoba Act. As you know, in October of 1869, the Prime Minister of the time decided, which was Prime Minister MacDonald, decided to send a delegation to speak to Louis Riel in the Red River Colony. The delegation was blocked at the border between what was then Ontario and the Red River Colony, and the commencement then of the Riel Rebellion. The Riel Rebellion is different in 1870 than the Northwest Rebellion in 1875. I'll get to the Northwest Rebellion in a minute. But the Riel Rebellion was finalized by an agreement to bring the Red River Colony and much of what is now southern Manitoba into Confederation. One of the primary negotiators of the agreement to bring Manitoba into Confederation was Father Richteau, who was the priest for the Red River Colony. Here is what Prime Minister MacDonald said in the House of Commons on Monday, April 25th of 1870. "The Richteau version contains what has been contained in no previous list given to me, a demand for separate schools for Roman Catholics supported by public money on the basis of population. I know that this will have to be conceded." Prime Minister MacDonald in 1870. Then, of course, Manitoba comes into Confederation, and there is the Northwest Rebellion in 1875. But before we get to the Northwest Rebellion, let's take a look at what the Manitoba Act said in 1870. Section 22. "Nothing in any law shall prejudicially affect any right or privilege with respect to denominational schools which any persons have by law or practice in this province when we join the Union." So, Catholic schools were embedded in the Constitution of the province of Manitoba when it came in. The same day that the Manitoba Act came into existence, the Rupert's Land and Northwestern Territory Order came into existence, attaching the Northwest Territories, which was all of Western Canada, all of Northern Canada, all of Northern Ontario, all of Northern Quebec, and Rupert's Land, into Confederation. But the world changed in 1875 with the Northwest Rebellion. The rebellion was put down. Louis Riel was tried for treason in Regina and was hanged. Let me tell you a little side story. You're going to let me go a few moments longer, aren't you? Haven't even got to Alberta yet. Let me tell you a little side story. The person who was the lawyer for Louis Riel was Sir Charles Fitzpatrick. Sir Charles Fitzpatrick is one of my favorite heroes of Canadian history. He was a Roman Catholic lawyer from Montreal. He was retained to act for Louis Riel in the treason trial in Regina, and he lost. But he felt so strongly about his client being in the right that he physically stood on the gallows and held the hand of Louis Riel as he fell through the floor. That just gets me all tingly. It's wonderful. Anyway, he went on to become the Minister of Justice under Sir Wilfrid Laurier, and he was the person who drafted the Constitution of Alberta and the Constitution of Saskatchewan, bringing them into Confederation in 1905. In addition, he went on to become the Chief Justice of Canada in 1913, and he sat on the very first challenge to the constitutional right to Catholic schools in Saskatchewan and Alberta. In 1913, it was called the Grattan case, and it came out of Regina. In any event, that was a long sideline, but I wanted you to know about one of my favorite heroes in Canadian history, Sir Charles Fitzpatrick. In any event, after the Riel Rebellion, there was a very strong pushback in Manitoba against Indigenous people, against Métis people, against French-speaking people, and against Catholics. And in 1885, the Greenway government of Manitoba passed legislation striking out, illegally, all of the constitutional protections of the Indigenous peoples, all of the constitutional protections of the Métis peoples, all of the constitutional protections of Francophones, and all of the constitutional protections for Catholic education. Now, there were two famous cases that went to the Judicial Committee of the Privy Council in the 1890s, the Barrett case and the Brophy case. I married a Brophy, so I remember that name. And they determined that it was illegal for the Greenway government to have deconstitutionalized Catholic education. And they ordered the Greenway government to bring Catholic education back into Manitoba. In 1895, the Mackenzie-Bowell government in Ottawa passed an order requiring Manitoba to bring back fully publicly funded Catholic education, and the Greenway government in Manitoba said no. There was an election immediately at the end of that year. Sir Wilfrid Laurier became the Prime Minister. It was his primary goal to bring together the Francophone and the Anglophone parts of Canada. And so he entered into a negotiation with the Greenway government that did not bring back publicly funded Catholic education in Manitoba, but on an agreement allowed Catholic teachers to teach in the public schools, for there to be Catholic classes taught, religion classes taught in the public schools, and allowed some designation of a portion of the taxes collected from Catholic ratepayers to go for Catholic education purposes within the schools. Provided, however, that they continued to pay 100% of all the taxes and levies for the public schools. That, of course, didn't last for very long because nobody wants to pay twice. But there is no doubt that the Brophy case in particular required, and the Government of Canada, the Mackenzie-Bowell government required in 1895 that Catholic public education in Manitoba be reinstated. It never has been. But every other right that was struck out by the Greenway government has been reinstated. So full recognition of Francophone rights in Manitoba occurred with the Manitoba language question about 20 years ago. Full rights for the Indigenous people and the Métis people of Manitoba were reinstated about 15 years ago in the Daniels decision of the Supreme Court of Canada. No one has yet brought a challenge to bring back Catholic education rights, but it's the only right that was struck out after the Riel Rebellion, which has not been reversed at this point in time in Manitoba. But let's go quickly to Alberta and Saskatchewan. As I told you, the primary drafter of the Alberta Act of 1905 and the Saskatchewan Act of 1905 was for Sir Charles Fitzpatrick. But draft number 1 of the Catholic Education Clause in those two provinces was drafted by Bishop Legel from here. Draft number 2 by Nicholas Beck, who, if any of you are from Edmonton will know, was the first chairman of the board of Edmonton Catholic Schools. Draft number 3s, 4, 5, and 6, and 7 were jointly drafted by Sir Charles Fitzpatrick and Monsignor Severetti from Rome. The protection given to Catholic schools at the end of a huge battle, 2 more minutes, a huge battle in the House of Commons resulted in the resignation of most of Laurier's cabinet. Most of the cabinet, particularly the representatives from Alberta, quit, and there was a constitutional crisis at that point in time. Laurier got over it, and his government survived, but it required a new election, which he won by, I think, a single seat to bring Alberta and Saskatchewan into Confederation. That's how tight it was getting Alberta and Saskatchewan into Confederation. But we finally determined that the rights that were embedded in the Northwest Territories Act of 1875, brought into the school ordinance of the province of, or what was going to become the province of Alberta in 1901, would become constitutionalized. Somewhere I stole the original version of the School Act of 1901, dated in 1901. Don't tell anybody. Look at the bookmarks they had in 1901. The rights that were constitutionalized were set out in sections 41 through 45 of the School Ordinance, Chapter 29 of the Ordinances of the Northwest Territories, 1901. Section 41 reads, "The minority of the ratepayers in any district, whether Protestant or Roman Catholic, may establish a separate school therein, and in such case the ratepayers establishing such Protestant or Roman Catholic separate schools shall be liable only to the taxes of such rates as they impose upon themselves." That is why we have a fundamental right to tax for Catholic education purposes and to spend for Catholic education purposes. It was written in 1901. And Section 45, after the establishment of a separate school district under the provisions of this ordinance, the separate school district and the board thereof shall possess and exercise all of the rights, all of the powers, all of the privileges, and be subject to all of the liabilities and methods of government as is herein provided in respect of public school districts. They were to be treated exactly equally by the province of Alberta. And several of the cases that I ran probably 15 years ago now were on the interpretation of sections 41 and 45 of the Schools Ordinance. We were always successful. That's what they mean. So the protection of Catholic education in Alberta and also in Saskatchewan was then constitutionalized in the Alberta and Saskatchewan Acts of 1905, particularly in Section 17, which said, Section 93 of the British North America Act 1867, it was the one that I read to you earlier, will apply in this province, with the substitution for paragraph 1 of Section 93 of the following paragraphs. Sub 1, nothing in any law shall ever prejudicially affect any right or privilege with respect to separate schools, which any class of persons have at the date of the passing of this Act under the terms of chapters 29 and 30 of the Ordinance of the Northwest Territories passed in the year 1901. Or, and this is the Lamont Amendment, Lamont also from here, or with respect to the provision for religious instruction in any public or separate school as provided for in the ordinances. So Alberta and Saskatchewan provide for constitutional protection for religious instruction, but interestingly, both in Catholic and in public schools. Only places in the world where there's a constitutional protection for religious instruction for public schools. Do they use it? No, it's there. It's the Lamont Amendment. And then in subsection 2, any appropriations by the legislature, that means any grants, any money being given by the legislature, or distribution by the government of any monies to any schools in accordance with the said Chapter 29, or any act passed an amendment thereof, or substitution therefore, shall not discriminate against schools of the classes described in Chapter 29. So government monies that are allotted are constitutionally protected to be absolutely equal as between public and Catholic schools. There may be no difference in the amount of monies given to Catholic schools as compared to public schools. I'm way over time, but I've taken you to how Catholic school rights evolved in this country from 1864 to 1905. And since 1905, there have been 40, 50-ish challenges to those rights. Every generation has protected those rights. Your grandfathers, your grandmothers, your great-grandfathers, and your great-grandmothers stood up every time there was a challenge, and those provisions won every time. You will be called upon to stand up when there's another challenge, and it's your turn. Thanks very much.